in case of union legislature is joint sitting of both houses of parliament. So why do we specifically say joint sitting of parliament, which is prescribed under Article 108? It means if we talk about state legislature, where there are state legislative assembly and state legislative council, Constitution does not provide for joint sitting in case of state legislature. So, in the Constitution, under Article 108, joint sitting is provided only in case of houses of parliament. So, parliament is to make law. So, the bill, in order to become an act, must be passed by both the houses of parliament, and thus both the houses have legislative competence. If a bill is passed by one house and after passing it is transmitted to the other house can simply pass it, and if it is passed by the other house also, it progresses on the path of legislative process and assent given by president, it becomes act. However, Constitution provides that what happens if a bill is passed by one house and the bill is rejected by other house. The bill is subjected to some amendment by the other house, which the two houses finally disagree. So one possibility is it can be rejected. Other possibility is the other house wants to make some changes which the originating house does not agree, and finally there is disagreement with regard to amendments. Constitution Article 108 also provides that the other house keeps the bill pending for 6 months without passing, of course. This is a fact provided under Article 108, that the other house cannot keep it pending, cannot prolong the process of lawmaking forever. So if the bill is kept pending for 6 months, however, how this period of 6 months is to be counted, Constitution provided that we should exclude the period of prorogation. Prorogation means the period of recess, which means the time gap between two sessions. So budget session, monsoon session and winter session. After budget session, winter session is held, whereas in between there is a time gap. Then after monsoon session completes, after monsoon session ends, winter session starts after some period of time. So this gap is called recess, and the process is called prorogation. So prorogation, period of prorogation is excluded, and adjournment of the house, which means if the house is in session and the presiding officer adjourns the house for 4 consecutive days. So the presiding officer can adjourn the house because of disorderly state of affairs in either house for 4 or more days. So that period is excluded. So in these 3 conditions, that is, bill is rejected by the next house after it is passed by the originating house, the bill is subjected to some changes which is not agreed upon by the originating house, and finally they are stuck as to the changes to be made, and this case bill is pending for 6 months in the subsequent house. In either of these conditions, deadlock or constitutional stalemate is created in the legislative process. Article 108 provides that in order to resolve the deadlock so created, the President is empowered to call a joint session. As the name suggests, joint session means a session of both Lok Sabha and Rajya Sabha together, combined session. What shall be the purpose? Of course, to remove the constitutional deadlock, to resolve the constitutional stalemate, because the bill cannot progress on the path of law and cannot become an act, and therefore Article 108 has empowered the President to call to summon, which means officially calling. The word summon means officially calling. To call a joint sitting for the obvious purpose of discussion about the reasons for deadlock and finally putting the bill to vote in order to pass. Now, Article 108 provides that joint sitting can be summoned by President. The mode of calling joint sitting. So, President can notify to the houses by sending message to the houses if the houses are sitting, which means if the houses are in session, because we have noted there can be recess. After the session is prorogued, there is recess, and during recess the houses are not assembling and not meeting, therefore there is no sitting. So if the houses are sitting, President is empowered constitutionally to send messages calling joint sitting. However, in the other event, that is, houses are not sitting, President can notify joint sitting by what is called public notification. This is specifically mentioned within Article 108. Now, we know there can be dissolution of what is called Lok Sabha. So, if the bill lapses due to dissolution of Lok Sabha, Article 108 says that no joint session can be summoned if Lok Sabha has been dissolved by President by an order. Joint sitting is not a possibility because Lok Sabha is dissolved. However, Lok Sabha is dissolved after President notified joint sitting, it will be held. If President earlier notified joint sitting and thereafter Lok Sabha is dissolved, Article 108 says that the joint sitting will be held to discuss the deadlock, the reasons for deadlock, and if possible to pass the bill. Now, we know there are rules of procedure. There are rules of procedure. For what purpose? So, rules of procedure with regard to Parliament is provided under Article 118. Article 118 provides for rules of procedure of Houses of Parliament. So each house is empowered to make rules of procedure to provide for conduct of business of the house. What about rules of procedure relating to joint sitting? So it is provided once again under the same article. It is not provided under Article 108 that who shall make rules of procedure of joint sitting. Article 118 provides for who shall make rules of procedure of joint sitting, and accordingly under Article 118 it is provided that President will make rules of procedure of joint sitting. But after consultation with the chairperson of Rajya Sabha and Speaker of Lok Sabha, right? Neither of the houses will make rules of procedure relating to joint sitting. Article 118 provides that the rules of procedure relating to joint sitting will be made by President after consulting Chairman and Speaker. Presiding officer in case of joint session. Provided under Article 118 itself. Speaker shall preside in case of joint sitting. It is the prerogative of the Speaker. That's why special position of Speaker in our Constitution. So Speaker shall preside over joint sitting. However, if the Speaker is absent, in the absence of Speaker, person determined under the rules of procedure relating to joint sitting shall preside. According to the rules of procedure, Deputy Speaker in the absence of Speaker shall preside. So how it is? Speaker shall preside. In the absence of Speaker, Deputy Speaker shall preside. In the absence of Deputy Speaker also, Deputy Chairperson of Rajya Sabha shall preside. What if he is also absent? Rules of procedure says that person, that is a member, as determined by the members present at the joint sitting, shall preside. So it is to be determined at joint sitting. So members present will determine one of them will preside in the joint sitting. So the order of the presiding officer in case of joint sitting. Very important to note that chairperson of Rajya Sabha is not authorized to preside over joint sitting. So in the absence of deputy speaker, deputy chairperson of Rajya Sabha is authorized, whereas chairperson of Rajya Sabha is not authorized to preside over joint sitting. The reason being that chairperson of Rajya Sabha is the Vice President of India, and therefore he is not a member of either house, and thus in case of joint sitting he is not allowed to preside over joint sitting. Now, quorum, that is the minimum number of persons required to convene a joint sitting. So in case of Houses of Parliament, Article 100 provides that 1/10 of total number of members of the House, not total number of members present. So 1/10 of total number of members of the House is the quorum. Same applies in case of joint sitting. So quorum in case of joint sitting will be 1/10 of total number of members of both the houses. So both the houses, total number, and 1/10 of that will be the minimum number of members required to be present in order to validly constitute the joint sitting. However, it is immaterial that out of the 1/10 members present, how many are from Lok Sabha and how many are from the Rajya Sabha. It is not to be seen. If all 1/10 are from Lok Sabha only, it will be valid constitution of joint sitting. So quorum. Joint sitting as per constitution cannot be held in case of the money bill. Why? Because joint sitting is to remove deadlock, and in case of money bill there cannot be deadlock between Lok Sabha and Rajya Sabha, because Constitution has given overriding powers to Lok Sabha in case of money bill. Rajya Sabha is given very restricted powers in case of money bill. Besides, in case of constitutional amendment bill, that is bill to amend constitutional provisions, Article 368 provides that the bill must be passed by the houses sitting separately. And thus, in case of constitutional amendment bill, there is strict equality of houses, powers of houses. So no joint sitting is a possibility in case of constitutional amendment bill. So in case of financial bills and in case of ordinary bills, joint sitting can be convened according to constitution. Now, which amendments could be discussed in case of joint sitting? It is provided under Article 108 which says that only those amendments can be discussed at the joint sitting which has caused the final disagreement between the houses. No fresh amendment can be taken up except if it is necessitated by the delay in the passage of bill. So, bill was considered by the subsequent house, the next house, after it is passed by the originating house, and thereafter joint sitting is called. In between there can be some time lag. So Constitution Article 108 says that if in between this time lag some changes are to be discussed which are compelling a reason to discuss something because of the time lag, those can be permitted. Therefore, primarily it is the amendment which caused the disagreement between the houses can be discussed at joint sitting, not any other agreement, not any other amendments. Besides, the presiding officer will have final say regarding the admissibility of amendments, because it says that something can be introduced if it is because of the delay and if it is necessitated by delay, but power is finally commanded by presiding officer whether to allow the discussion on some amendments, some issues, or not to allow. Now, how to pass the bill at joint sitting? It is to be passed by a majority of members of both the houses present and voting. So, members of Lok Sabha and members of Rajya Sabha both are present at joint sitting. Majority of the total shall be taken up, and the presiding officer will have casting vote. That is, if there is tie in favor and against the bill, the presiding officer can cast his casting vote. So, because of such pattern of voting, it is obvious that Lok Sabha, which has more number of members, and the ruling government commands absolute majority in Lok Sabha, which may not command majority in Rajya Sabha, may see the bill clear in case of joint sitting because of the overwhelming membership in Lok Sabha and government having absolute majority in Lok Sabha. So 545 members in Lok Sabha and 245 members in case of Rajya Sabha, total 790 members. So there is a huge gap between the membership. So therefore it is said that obviously because of the dominant position in Lok Sabha, the government, which may not be able to get a bill clear in Rajya Sabha, will be able to get it clear in joint sitting. So far 3 joint sitting has been convened. First was in 1961 because of disagreement over amendments to dowry prohibition bill. Second joint sitting in 1978 because of rejection by Rajya Sabha of Banking Service Commission repeal bill. And third joint sitting was held in 2002 when the ruling government wanted to replace Prevention of Terrorism Ordinance by Prevention of Terrorism Bill and want to make it a law. So Lok Sabha passed it, but it was rejected by Rajya Sabha. In all these 3 joint sitting, the bills were passed by the joint session because of the obvious reason that Lok Sabha, which has overwhelming majority, in total membership. Thus, the government is relatively comfortable to get it passed. Besides, joint sitting is not only to remove a deadlock, it is a regular feature of Indian parliamentary system also. So, joint sitting is convened and addressed by President first at the beginning of first session each year. So, by default, the first session each year is the budget session, which starts in the last week of January, the calendar year. It is called the first session. So, President in the Central Hall of Parliament jointly addresses both the houses. Besides, joint sitting is held of Parliament immediately after general election to Lok Sabha. So, these are the regular joint sitting. So, one is a confirmed joint sitting which is every year, that is the first session of Parliament. So, this is all about joint sitting of the houses, and as we noted that joint sitting is a possibility only in case of Parliament, not in case of state legislature. We will discuss about the deadlock, if any, possible in case of state legislature.